So welcome to the presentation. The first screen is a welcome screen and essentially reminds you that the presentation is for informational purposes only and does not create a lawyer-client relationship with the audience. It's legal information, not legal advice. And so if you have issues or questions that are not addressed here or that you'd like to have addressed, then please feel free to contact me via Carla, and we could definitely set up a formal Q&A session. So can we move to the next slide? Okay, and then just a little bit about me. So I'm a small business lawyer working at a boutique firm formerly of a large Canadian law firm and in between at a large British law firm. And let's move on to the next slide. So sales and customer agreements is the topic that Carla asked me to speak about today. So essentially, I will sell you X, and you agree to some terms, some payment terms, and so on. X could be a product or a service, and so my presentation is not specific to products or services, and I'll try to touch on both. So let's move to the next slide. Okay, so I made a list here of core elements. So if you recall, in the CloudTown tool, there's a core elements button that's essentially an index that walks you through the nuts and bolts of a legal agreement. So what I've done here is I've broken out several of the core elements, and following this presentation, I'm going to post a sales and customer agreement onto cloudtown.com, and it will contain these core elements. So you'll be able to visually see the language that's associated with these. But for this presentation, I think I'll just walk through and give you the high-level explanation of what these terms are and how they work. So the first term is parties. So essentially, if you're selling a service, then in your contract you'll name the parties, yourself as a legal entity, and the counterparty who's a legal entity. The counterparty can be a person or a company, but it's important that it's specifically named as such, and that's important for a couple of reasons. One is if you're in trouble and you're at odds with your counterparty, and you need to go to court, then the court wants to know who the proper counterparty is, who the proper legal name is. Second, sometimes you'll need to register something on a government site relating to your counterparty. For example, if you're offering a loan, then you need to know who you're lending money to, and the government sites are very specific about the legal name of the counterparty. So number two, just going down the list, and we'll come back up to the middle column after, is description of product or scope of services. So when you're selling a product or a service, it's important that you're very specific about what you're selling as well as what you're not selling. So if you're selling a base model BMW, then it should include, the product list should include what is included as well as what's excluded, so that the purchaser is aware that they're paying only for the items that are included. It's awkward and troubling if the purchaser comes back and says, I thought these bells and whistles were included and they're not. So that should be made crystal clear. Now, in this, when I say scope of services, that relates to a consulting type arrangement, and customers in that realm will often ask for certain services and then will realize they need more services. So there's an exchange between the counterparties to try to come to terms on that. So it's very important that the scope of services is clearly defined. Otherwise, you could be the seller, the vendor could end up in a situation where they're including items that takes them a lot more time than was originally anticipated and makes the project a bad bargain and possibly unprofitable. So moving down to the next one, fees and charges. Again, here it's important that the amount owed is clearly stated. Any additional fees for being out of scope or extra product features should be clearly stated. Currency, whether it's Canadian currency or some other currency, should be clearly stated. The item right below tax responsibility, it should also be clear as to whether the taxes will be included in the charge or outside of the charge. So I think it's typical on a product that you would go to the counter retail store and expect to pay tax. If your sale is a business to business, then there's no counter, so it's important that it's specified right in the agreement that one party is responsible for the tax. Moving on to the middle column, rejection and acceptance period of the product or services. So at some point, the person receiving the product or service has to agree that the product was properly delivered. This is important in both products and services. So with products, you may offer, or there may be a government-required return period. So essentially, during this period, the party who receives the product can review it or enjoy it and decide whether or not it's something that they want. So you'll see this a lot in retail stores where there's a 15-day return period. At Hudson's Bay Company, for example, or other stores have a 0-day return period and it's exchange only. So in the services world, that's also a key point. At what point in time is the service delivered accepted? And that point in time is important because services companies want to bill their customers. So once it's accepted, then it's generally agreed and also often written in the agreement that at that point in time, the services company can now bill the customer. So moving down to the next item, warranty period. Warranty period is different than rejection and acceptance. So once it's accepted, you enter into this period in which you are warranting as the vendor that the product is of good quality and will continue to work. So that warranty period can be determined between the counterparties. It can be 0 if the product is sold as is, or it can be 30 days or 90 days or a year. So that's an often negotiated point. It's in the interest of the vendor to keep that period very short, and it's in the interest of the customer to keep it as long as possible. On the same note, very similar to the scope of services, the warranty has a scope as well. And so it's in the interest of the company to indicate what's in scope, what's under warranty, and when the warranty falls off. So it could be the case that if you buy a product and then you open it up and reverse engineer it and disassemble it, warranty is voided. Just in the very same way, if you buy services and then you hire other service providers or work with it internally with your team and rewrite the whole piece of work product, at that point in time, the warranty period of the services is likely voided. Now, I say is likely because that point usually is negotiated within the agreement, so it's not a default position, but it's one that probably should be written into the agreement. So moving down the column, the next item is payment terms, and Part A, payment due date, and Part B, interest rate. So payment terms, it's important to specify when payment is due. So again, going down the analysis, so you agree to deliver a product or service, you deliver it, the party receiving it accepts it, you send the invoice, and that could all be at the same time. So there could be no gap in time there, or there could be a gap in time of 30 days or something like that. After acceptance, the party receiving the product has to pay you, and it could be an immediate requirement to pay, or there could be 15 days or 30 days or 60 days. It's a negotiable point. The larger the value of the work and the larger your counterparty, the more likely it is that there will be a gap in time. So certain large counterparties, let's just say banks or telcos or big retailers, might require a 60 or a 90-day payment period, and although that's not ideal for the vendor, it's at the same time difficult to negotiate out of because your customer is so big and you're really happy with the potential order that often you'll accept those terms. So moving on to the next point, which is interest rate. So if you are offering some deferred payment terms, it's common that you would ask for an interest rate, and you generally should ask for an interest rate because if there's no interest rate, then there's no incentive for the counterparty to pay on time within 60 or 90 days, for example. And also, while many companies don't enforce the interest rate provision, if things get ugly and you end up in court, having an interest rate provision in place is useful because part of your claim would then be the interest that you haven't collected. So continuing on down the middle column, customer promises, representations, warranties, and covenants, and top of the following column, vendor supplier promises. So each party promises something. On a product sale, so if you go to a retailer and buy a shirt, you don't really promise very much. So this changes depending on the nature of the customer and the vendor. The vendor in that same shirt example promises that the shirt will not fall apart, and that's part of the warranty discussion. Now, if we're looking at a bigger purchase, like let's say consulting services valued at $100,000, then each party will likely promise more. So the customer will likely promise that they will deliver information on time and make their staff available for discussion. The vendor will likely promise that that they know what they're doing and that they will deliver on time, that they will use a normal standard of measurement for their skills and abilities, like a similar standard to what would be expected for a vendor of the service that they're providing. And there could be a dozen of these types of promises. So it is typical in a larger customer vendor agreement that, and when I say larger, I mean larger dollar value, that there would be a series of promises, more likely from the vendor and a few promises from the customer. The customer promises, as noted, would be timeliness on response, timely delivery of information, and access to staff. So moving down the third column, the next one is limitation of liability. So for limitation of liability, this is one that's very important to the vendor, and essentially here the vendor would be trying to limit their liability to some cap. It could be zero, so if the product or service is sold as is, then they would say we take no liability, or we take liability to the value of the value of the product. So again, if you're purchasing a shirt at a retailer, then the value of the liability could be the value of the shirt. For larger transactions, for larger commercial transactions, so a services contract, for example, that is $100,000 in value, liability could be something greater, like it could be some percentage of the value of the contract, or the payments made to the vendor in the months prior to any such claim, or it could even be some greater amount, because although the value of the contract is $100,000, the possible consequences of some mistake made could be worth more than the value of the contract. So the limitation could be, $500,000 in a $100,000 contract. And in a situation like that, the vendor would typically have insurance that would cover any such claims. So continuing on down the far right, indemnities. Indemnities is a point that both parties might pursue on a larger value contract. So essentially, this is different than liability, because the liability would be between one party and the other, so the vendor versus the customer. Indemnity would reflect some damage to a third party, so somebody who's not party to the agreement. So for a product, it could be the shirt catches on fire and hurts other people, or the BMW catches on fire, or it's in the services world, it could be that you're selling software and it doesn't work, and it's bank software, and now you have bank customers who are not able to access their funds. So it's something like that. So the indemnity there would be the customer would ask the vendor to pay for any damage to a third party. So again, this is a point that's often negotiated, and it's in the interest of the customer to try to put this protection against third-party claims into the agreement, whereas the vendor really doesn't want that, because it creates some unknown, dangerous potential liability to the vendor. A way to deal with that for the vendor would be to try to come up with some limit to it, so a cap similar to the one I discussed in limitation of liability, as well to seek insurance. And the last point I wanted to talk about in the third column is dispute resolution, and it's good to have some mechanism to manage disputes. So it could be if we're going to be mad at each other, first we have to resolve by mediation, or first we have to talk about this problem with senior management, have a cooling off period, and then go to mediation, and then go to court, or then go to arbitration. Court versus arbitration is often an point of argument when drafting an agreement. Both have pros and cons. One of the best reasons for choosing arbitration is that you can set a time limit within the agreement for when the arbitration must commence, and therefore the parties will resolve the dispute within 6 months or 3 months rather than potentially 5 years in litigation. Litigation is faster. They're both very expensive. Parties would definitely prefer not to have to go there if possible. So, Carl, I think that takes us through the elements of the sales and customer agreements. Did you want to look at the last page? Essentially, was recommending a quick tour of Clausehound, which we can do, or if we have any questions and answers, I'm happy to take those as well.
Well, why don't we do the quick piece of Clausehound again? So we started that a little bit, but I think that the key piece here is that under Clausehound, we went through one example and then going through the components of the sales and customers agreements. What I really like about that is that any small business owner with almost any one of their relationships with either a supplier, vendor, or any of their customers, or even some of, let's say they contract work out. I mean, for any of those case purposes, you can use the components that you just talked through. But if there's any other type of relationship, I think definitely going through Clausehound and starting with some of these other elements, at least some of the language you've already explained. So that was really good.
Yeah, that's right. So a sales agreement actually isn't posted as one of the agreements in Clausehound right now, but we'll post it after this call, sometime in the next week or two, and I'll let you know, Carla, if you want to distribute that to the group who signed in.
Okay.
So then you'll be able to walk through those 12 elements and see the legal language that are associated with it. But if you wanted to take a pop into Clausehound now, then I can sort of walk you through it so you can see how that would work.
Okay, great. So I'm in Clausehound right now, so we'll just go back to the main page again.
Sure.
Okay, and everyone can see it? Yes?
Yeah.
Okay, so under Clausehound, I guess it's create a document is probably the best. Is that where you wanted me to go?
Yeah, let's go back to create a document.
Okay. So I guess
If you want to click on agency agreement, that's a little closer to a sales agreement, so it has a lot of the sales elements.
and it just came up. Can everyone see this? Yeah. Okay, good.
So on the right, you could see a fully formed agency agreement. So you'll see some of the points that we talked to if you're scrolling through. After the definition section, acceptance is in there, warranty is in there, compensation, payments, payment terms, client default. The agreement is pretty hardcore, so it might have a lot more terms that are necessary for for a very simple sales agreement. But as you know, this tool is intended for lawyers, so it's over-inclusive rather than under-inclusive. If you click on the core elements button at the very top, this is the easy way to walk through the agreement. So you can see if you scroll down that it has some of the points that we had discussed. Confidentiality, non-solicitation. So some of these weren't discussed, but parties was discussed. Arbitration was discussed. Dispute resolution was discussed. And so at a later time, if you're interested, you can just sort of pop through and use the middle column as a guide. The core elements may not map directly in all cases, in all agreements here. In some cases, we've added more core elements than you would find in a standard agreement, and if so, then it won't map directly. But it's a good index for what is likely important in that agreement. And so, as noted, we'll be posting something like this for the topic of our discussion today for sales and customer agreements very shortly.
So, Raja, you did mention that this was pretty hardcore, so it has quite a few different clauses to it. And I guess one thing I'd love to learn a little bit about is when does it not make sense to have such a long agreement, and when does it make sense to have a long one?
Right. So in most cases, parties don't like signing a long agreement. It's what's in there. They're not sure, especially if they don't have an internal legal team. So we're sometimes instructed to make it as simple as possible, and we'll use simple language instead of long-form language. So it really becomes a question of a few things. One, what's the value on the agreement? So if you buy something at the retail store, if you flip over your receipt, you'll see very simple terms, and you'll probably see a link to terms and conditions of the store. So that's a simple agreement. It's intended to make it very easy for the customer to understand what their warranty period is and so on. At the same time, if you're representing a client on a bank as customer transaction or telco as customer transaction, then the long form agreement comes in, and it could be 30 pages talking about the same points. So in those situations, everyone has, there's a lot of money at stake, and there's a lot of time being put forward by the vendor. So the mechanisms have to be very detailed just to make sure that in the event of a dispute, you can walk through and very easily understand how the acceptance period is supposed to work, for example, or how the warranty period is supposed to work.
Right. And I think one thing that I've always noticed when I've ever had a lawyer look at any of my agreements is that their take on it is not that the agreement, when you agree with someone else, then that's not the problem. It's making sure that your contract protects you when the two parties don't agree.
That's exactly right. So the points that you care about on agreement are how much am I paying, what am I getting, and when will that be delivered, for example. But the points such as warranty, acceptance, dispute resolution, they're not ones that you really typically worry about on day zero when you're entering into an agreement in good faith. But at some point in the future, if there's a problem, then you're really reading those provisions very carefully. So sometimes it's important to have those carefully negotiated in advance.
So I have one more question before we open it up, and I'll stop the recording, is we're looking at the document tools in the list here. Now, everyone up here is going to be a small business owner, basically, or a small business consultant. When looking at some of these, what are the top ones that a small business owner should be using as the templates, like to start? Like what are some of the mandatory contracts or pieces legally that they should be starting with here?
Yeah, so I think the whole list is good. We've diluted our bigger list down to this list. So what you're looking at are commercial activities, and these are probably our most searched agreements right now. So the things that you're doing on your day-to-day commercial endeavors would fall here. When you're starting a business, company formation, shareholder agreement, option plan, human resources, you're hiring, then you'd have a consulting agreement or an employment agreement or a share subscription agreement, for example, to deal with option plans. And then corporate finance, you might take a loan, so a general security agreement is often dealt with, and term sheets if you're looking at bringing equity investors in. So we sort of try to categorize it in life cycle stages of a company, and I think you're seeing basically our top 14 or 15 most searched documents, but I think another dozen to follow shortly. So stay tuned and keep an eye out on this page as we continue to populate it.
Awesome. So it's almost looking and using that page as a checklist for a small business owner. That's perfect. Okay.
Exactly.
Okay, so we do have a question. Is it possible to get the templates or outline of various agreements and contracts so we can use them as a reference point? Yes, so basically, Raja I'm going to stop the recording now.